excited about the three people who are here, and I've got a whole notebook ready for taking notes on this, in addition to the video that I'll be able to watch later, because of the work that they've done already and the kinds of things they'll present today. So I think it should be really interesting. I wanted to just contextualize the issue of reparations a little bit in the sort of view of Armenians on the left, Armenians in progressive politics, or whatever we can call what we're doing, and sort of follow up a little bit on what some of the speakers today were talking about in terms of having a more maybe global perspective and a more historical and complicated perspective about Armenian issues. And as we talk about particularly Armenian reparations, we have to remember that this is an issue that affects a slew of groups across the world. And in fact, in the last maybe 10 years, we've started to see what people are terming a global reparations movement that the Armenian case is fitting into. It runs, the gamut of genocide victim groups. Certainly, we were just talking with Building about the issue of Theriault in Germany. And the Theriault, who were a very small people and were the victims of the actual first genocide of the 20th century that we know of, have a reparations movement in Germany now for a genocide that happened more than 100 years ago. Across Native American issues, there's just a big settlement in the United States relating to not directly genocide reparations, but relating to Native American abuses of Native Americans by the U.S. government that resulted in a settlement of over $500 million, which was announced this week. And there are a host of other cases. We can go to Australia, Indigenous peoples in Canada, and across the board. But also many other kinds of human rights abuses. The comfort women who were victimized as sexual slaves by the Japanese government had a long-standing reparations case that they've taken into court in Japan and so forth. And even going to corporate issues, and again, to pick up the sort of underlying themes of this conference, we probably have all forgotten about the Bhopal, India disaster by Union Carbide in the 1980s. That produced a very significant reparations movement as well. And as we think about the Armenian case, I think it's really important to understand it as part of a bigger context. And I'll sort of, in putting that into perspective, I would like to say that when we think about reparations, we're not talking about something as a narrow sort of response to a particular set of problems, but really a politically transformative process, social and cultural process. And if we really think about what the Armenian Genocide is a part of historically, it's really part of more than 500 years of genocide, colonialism, slavery, apartheid, mass rape, economic exploitation, and aggressive war that really have shaped the globe. There isn't a place in this world you can go that hasn't been touched from the perpetrator side, the victim side, or both sides by this process. And when people start talking about reparations, what they're really talking about is not groups just advocating out of self-interest to get some money or something like that. They're really talking about how we address this incredibly deep foundational process of destruction and hierarchical ordering and the sort of related issues that have come out over the past half millennia. How we address that in a way that can start to maybe bring victim groups back into viability and vibrance, that can start to reshape the globe toward a much deeper and better social justice than a lot of the surface level social justice movements. I'm not saying that all of them are, of course, but that a lot of the rhetoric that we sometimes hear around social justice. I mean, this is a very deep-reaching movement that's looking at fundamental social change in the world, and I'm really excited to hear what our three panelists have to say about that. One last shameless self-promotion moment. I'm also part of a reparations report on the Armenian Genocide Project, and we just had a website launch, and our full report is going to be available in about a week on the website, and there should be coming direct from Armenia, I think, where it was printed, some versions of the executive summary and so forth that will be available later. So if anybody has any questions about that, there's the website. With that, I'm going to turn our attention over to Tom Samuelian, and I'm going to say that I'm almost intimidated to be sitting next to him with the accomplishments. If you just read through the incredible accomplishments that he has had. I mean, he's a true Renaissance man, going from translating medieval Armenian manuscripts to cutting-edge legal cases. I mean, it's really stunning. I won't say anything more about it, but you can read more. But we're really happy to have you.
Thank you very much. pleasure to be here. Today's panels in the morning were very stimulating, and I'll try and weave in some of the very, very important ideas that were raised during the first two panels into this discussion, because although we think of reparations as being somehow separate from recognition, actually it's all of a piece, and it's really important for us to see how reparations is actually the solution to a lot of our problems. It's the way out of the what I would call the Armenian Genocide predicament that we all find ourselves in. And when I say we all, not just Armenians and Turks, the whole world community is in this strange predicament. We've got there's a crime that has been condemned by lots and lots of countries. Today, if the Armenians and Turks were to shake hands and say, let bygones be bygones, let's kiss and make up, it wouldn't change the fact that a horrible crime took place, and it took place with impunity. There has not been an appropriate response to the crime. When you have a crime where there has not been an appropriate response, you end up with a downward spiral. We end up with a vicious spiral to the lowest level of barbarity, which we see replayed and replayed and replayed throughout the 20th century into the 21st. So, let bygones be bygones is nice for a tiff between neighbors, but it's not an answer in a legal framework when we're talking about a legal discourse, which creates a new precedent for a lower level of international norms, because the international norm prohibiting genocide and condemning genocide requires an appropriate response. Okay, and the response is not simply let bygones be bygones. That's not enough. The perpetrator needs to redeem itself in some way, and unfortunately, we have a problem here. There's a reason that the Armenian genocide predicament persists, and it actually isn't because of the Turks or the Armenians. It's actually that the problem starts with the community of nations and the leaders of the leadership of the community of nations, which leads us probably right to Washington. Tomorrow, if Washington were to declare that the Armenian genocide were recognized, this issue would begin to unravel in a very interesting way. Take 2 minutes to just imagine what that world might be like, how it might unfold. Because at that point, the witness-in-chief of the Armenian genocide and the organizer-in-chief of the international community would have called the act by its proper name, and then been required to take the necessary steps to remedy. There's a Latin phrase, ubi jus, ibi remedium, which actually was in the studies, that's one of the studies that are included in this very interesting collection of studies that's just been published by the Armenian Genocide Reparations Study Group, and I give you high praise for having organized all that and made that public, and it's really an important contribution to this discussion. The flip side is that where there's a wrongdoing and there's not a remedy, people begin to think that there's no wrongdoing. That's our current state of affairs, and it's unacceptable. It's unacceptable to the civilized world, and it should be unacceptable in Washington as well. Unfortunately, that has not been the case so far. So one thing is to decouple recognition from reparations. Recognition is an important thing. It's about a criminal act. Reparations is about making the victim whole. That's the inalienable right of the victim. No one can take that away from the victims. Then the question is, who has the duty to make the victim whole? That's a more complicated question. Most people would think, oh, it's the Turks, of course. Actually, a lot of the harm was done by more than just the Turks. And we know that during World War I, certainly, and actually for the half century before that, there were plenty of European instigators and beneficiaries of the Armenian question, all of whom benefited greatly from at the expense of the Armenians. And certainly during World War I, Germany's role has been well documented. Certainly they have some liability. And there's no reason why when we raise the issue of reparations, we should just focus on Turkey. But beyond that, the Armenian question or the Armenian genocide issue was never really given a proper hearing, nor the reparations claims after World War They were presented. They were summarily dismissed by a commission during the Versailles conference. And the chair of that committee was none other than an American brigadier general who dismissed it without even looking into it any further, McKinstry. And I think that you turned to that and looked at that in your report as well. So I won't go into that in more depth right now, but I'd like to go through some major points, step by step, of what we might do as we go forward. First of all, pursuing genocide recognition and reparations independently, separating the criminal from the civil claims, remembering that genocide is a crime against humanity, and that we should be and that not just Armenians, but the whole world should be demanding condemnation of the genocide. Remembering that reparations are compensation, and that it can't be taken away from us, even if there is no genocide recognition. There's a notion that you have to wait until Turkey issues a unilateral admission of guilt for the genocide before there can be reparations. Not true. Not true. There's more than enough evidence of the confiscation and destruction of Armenian property and lives for the claims. And those facts are incontrovertible. Whether or not they ever confess or recognize the genocide, whether or not the United States chooses to or not. The problem with the United States is that we're in the, and this goes to our first panel's discussion, we are in the court of public opinion. The court of public opinion is an endless talk shop. And they've taken only one really, one typical measure that's used in courtrooms, which is creating reasonable doubt. That's all you need to do. Create reasonable doubt. You'll confuse it. You can't get a verdict, and it stays in limbo. They've kept us in limbo for now 100 years. And not just us. They've also kept the Turks in limbo. Question: is it to protect the Turks? I don't think so. Let's try another hypothesis. Maybe it's to torment the Turks. Maybe it's a way of taming the Turks. Maybe it's a way of manipulating the Turks. Turkey is being manipulated, and certainly certain groups in Turkey have been saying. They've named the game. The Americans and the Israelis and others and the Brits who don't recognize the genocide are keeping it hanging over their heads. So they can always pull out the Armenian trump card and say, you know what? You don't want to toe the line? We'll play the Armenia card, and then let's see how you like it. And that game is being played. It's a very nasty game. And it's even more frustrating for Armenians to be part of this blackmail, in that we're being totally reified, and the harm that happened to us as a nation for the past 150 years, if not longer, has been turned into a commodity. It has taken on a life of its own since, since 1922 or 1923. So now we've got this period after 1922-23 where people have been basically externalizing the costs of their foreign policy toward Turkey and making the Armenians pay for it. Armenians, you just wait. And the beauty of it is the Armenians continue to be able to cooperate with this by constantly protesting. Say, if Foggy Bottom, the diplomats sit there and they tell their Turkish colleagues, you know, if it weren't for us, those Armenian rabble would be after you right now. We're protecting you. Okay? And we constantly raise the noise, we create the pressure that they can then trade on. Not that I'm saying we shouldn't raise the pressure. We should also be aware that we are enablers of the very deprivation of a resolution that we're seeking. So we're in a very strange situation in terms of international dynamic. And so one always has to ask what the realists ask: who bono? Who benefits? Who's benefited from this long delay, and how much have they benefited? Let's leave aside the actual claims that were presented at Versailles, which were what, 19 billion francs. And one can do different types of manipulations on those and calculate the numbers, add, convert it into dollars, figure out what the current value is, add the interest, you can get a number. And that number varies. I think in the study that was just published, it's something like 80 billion. Other studies have it at close to $500 billion. That sounds like a lot of money. It isn't. It isn't. And I'll give you some other numbers to put that in context in a moment. But the reality is that that was only for part of the harm. That was just the property and harm to life. That assumed that we were going to have Western Armenia. That assumed that there was going to be a Western Armenia. So that was in addition to the homeland. That was in addition to a homeland, a much bigger homeland. So we have to keep all that in mind when we work with these numbers. But there's a bigger number out there, which is what has been the benefit to the United States of exploiting the Armenian Genocide issue for the past 60 or 70 years? I don't know. They've used it to keep Turkey in line. They've used it to help Israel have an ally. They've used it as a counterbalance to the Russians. The U.S. the U.S. defense budget during that period, by some calculations, in 1911 or 1912 dollars, is something like $400 billion a year. Okay, $400 billion a year times 60 years. It's a big chunk of money. How much of that was at the expense of the Armenians? How much of that cost did they externalize to the Armenians? Because they had the Armenian card to play, how much did they save the American taxpayers? Basically, the beneficiaries are the American taxpayers, the European taxpayers, who have actually been subsidized by the Armenians. That sounds very strange, by delaying the resolution of the Armenian Genocide. That sounds strange, but that's how most of the world works. Most externalities work that way. It's the poor communities that are polluted that allow us to have cheap goods, to be perfectly honest. It's the poor communities whose rivers and forests are cut down that are around the world that pay for everything else that's cheap in the world. Okay? So it's not the rich that pay for externalities, it's the poor and the weak that pay for externalities. There's nothing new about this in the world. Thucydides said it in the Rebellion Dialogue, equals get to negotiate, everyone else gets to gets what they get. So we've gotten what we've gotten because we are not powerful enough, not wealthy enough, and not strong enough to demand a suitable and a proper remedy to our situation. And that's partly because we have insufficient, the international community and the international institutional framework has insufficient mechanisms for addressing this issue. We still are in a state of anarchy when it comes to this type of issue. It's nice that we have an international court. The international court goes after individuals. It's nice that we have the United Nations. That's a political body. We really don't have a lot of clout to be able to get anything done there. It's nice that we have the European court. Let's see what happens in Pericik. There's a possibility that that case will create some precedent, some useful dicta that will turn into the basis. Really, all we need is a small fulcrum to begin to get the issue moving. And there are people working in that direction, including the Armenian government. One big difference between now and let's say 60 or 70 years ago when these issues started percolating is that we do have a state, and our state has taken positions on these issues, and is taking more positions on these issues, and it is able to advocate for Armenian rights. And we also have a church that is finally asserting itself in reclaiming what was wrongfully taken from it. Those two things are very, very important steps forward because both of them are international. They have standing in international in international fora that we as individuals, each one of us, don't have. And that's a big problem. The standing issue is a big problem. So what do we do from here in terms of what we demand? And I think we should separate the substance from the process. We should demand everything that we can possibly ask for. Okay? Any cognizable claim should be asked for. Nothing should be dismissed out of hand because it's infeasible or improbable, or there's going to be a counterclaim, or there may be an objection. That's all left aside. This is a discipline that lawyers learn very early on. You do your analysis on what your client's best claims are, independent of what the likelihood is. And then you do the likelihood analysis and you figure out what the weaknesses are. First thing you should do that. So there's lots of things we should be able to claim. Some of them are already ours to claim. Now there's two types of harm in the world. There's reversible harm and irreversible harm. Reversible harm is pretty straightforward. It's, properties can be given back, like church properties. Yep. Rights of way can be granted to the city. Historical monuments can be preserved, can be properly described. Those are reversible harm. Other kinds of reversible harm are rather interesting that people don't often talk about, but they're used in the United States and elsewhere. Natural rights, natural resource rights. Turkey has $2.5 trillion in known mineral rights, 2.5 trillion. A lot of them are under the Armenian highlands. Why should Turkey get the only benefit from that? Isn't there a way to claim some of that? Certainly American Indians or Native Americans are claiming royalties and rents for certain properties in the United States on that very basis. There are indigenous lands. Question. Have we posed it? Have we pursued it? No, we haven't. But there's plenty of money out there. There's plenty of money out there from the United States, from England, from Germany, from Israel. All of them are spending huge amounts of money on defense and largely benefiting from externalizing the cost to the Armenians. We should be demanding that too. We should implicate all of them because they deprived us of a resolution to this for over 100 years. The question is where? Now let me talk about irreversible harm. Irreversible harm obviously is the lost generations and lives. What do you do about that? We should be a nation of maybe 40 million. We're a nation of 10 million. And it's a direct consequence of the genocide. No amount of money would possibly compensate for it, and to talk about it in terms of money seems crass, but that's what lawyers do every day. That's the way the world works. We shouldn't be afraid to turn claims that cannot otherwise be reversed into claims for money. What would we do with the resources? A lot of people have talked this morning, some people said, Armenia isn't the country we hoped it would be. We want it to be a better country. From my point of view, it's amazing it's as good as it is, given the resources we have. And I've been living there for the past 18 years, or 16 years full time, and going back and forth for more than 20. And I can say that it's improved remarkably. It's an amazing country. But nevertheless, with a lot more resources, you're a much more prosperous country. It's as simple as that. It would be a lot fairer. It's a lot easier to have social justice when you have lots of money. It's as simple as that. Give us $500 billion today, and it generates. Why not? Why not? It's for the asking. That's my final point. My final point is first we have to ask. We're not asking. If you don't ask, you don't get. If you don't ask, you don't get. People aren't asking for it. So we should be asking for everything we possibly can. We have to articulate it and support each one of the claims properly. As far as process goes, I'll just wrap up with that because I know I'm out of time. The process issue. Yep. Got a minute? Okay. The process issue is this. In the court of public opinion, we will. It's almost a losing battle. We're treading water because anytime they want to, they can use the one-step reasonable doubt for a reasonable price, as we used to say in law school. That's it. You just go. You pay a lobbyist, and they create some reasonable doubt for you. Muddy the waters a little bit. Everyone is totally distracted with other big problems. They're daily doused with all sorts of atrocities. Now you're talking about something 100 years ago. I don't know what to think. That's it. They close down, shut down, forget about getting into the public pressure from there. Nevertheless, it's good to work on it. We shouldn't give it up. But I think instead we should be pushing for a solution, some kind of a multilateral, closed-end process. When I say closed-end process, like a court process. What's good about court processes? First of all, they can be initiated by victims without getting everyone's permission. Secondly, once you're in the process, you're assured of the result. That result may be difficult to argue for. That result may be difficult to argue for, maybe we're not ready for it. But that kind of a process is what we need, and it should be a multilateral process because this is not just between the Armenians and Turks. This is a world problem, it needs a world solution. It took a lot of countries to create this predicament, to create this mess. It's going to take a lot of countries to fix it. Since we're the ones that know the issue the best, it's up to us to begin to advocate for the kind of solution that will actually resolve the predicament so that it doesn't carry on for another generation. Thank you.
And our next speaker is Umit, who, again, I will refer you, as a graduate student, I mean, my gosh, I think when I was a graduate student, I couldn't have gotten through the first line of his bio here. And the accomplishments he already has under his belt are tremendous, including a really important book on this issue with Taner Akşam, The Spirit of the Laws. Tremendous work. Again, I'll refer you to the full biography. He's a grad student at Clark, and if you look around the room, including up here before, you'll find that the Clark Holocaust and Genocide Studies program is extremely well represented in scholarship on the Armenian Genocide today, and actually within the sort of progressive framework. So a couple of people over there, over there, and Patrick somewhere. So we really welcome you and are excited to hear what you have to say.
Thank you very much for this generous comments, and thank you for having me here, for the organizer. Today I'm going to talk about a different aspect, or some particular aspect of Armenian genocide, which is an understudied subject matter vis-a-vis other aspects of Armenian genocide, like assimilation, mass extermination, and mass killings, atrocities, and of course conversion. And today I'm going to be talking about the material destruction of Armenians within the Ottoman Empire in 1915 through so-called legal mechanisms, which has been known as abandoned property, envali Türkiye kanunu. So, of course, what I mean by abandoned property law, we are talking about numerous legal rules, statutes, a number of regulations, a number of communiques, and so forth. All these legal bodies, which were founded and promulgated by Union and Progress Party during the genocide, first and foremost. And all these legal so-called legal mechanisms were inherited and revised and also changed by the Republican government, or the Kemalist government, during right before the declaration of Turkish Republic and after. A series of laws and decrees were issued in the Ottoman and Turkish Republican periods concerning the administration of the belonging left behind by the Ottoman Armenians who were being deported in 1950. These laws and regulations were known as abandoned property laws. These laws were a structural element of the Armenian genocide of 1915, as well as today's legal system, and yet, paradoxically, they continue to this very day to protect the rights of the Armenians to their properties. The majority of the relevant laws and regulations were issued in the Republican period. The Republic of Turkey and its legal system, in a sense, were built upon the seizure of Armenian cultural, social, and economic wealth, and the removal of the Armenian presence. In its present form, we can say that the Republican legal system institutionalized the Armenian genocide of 1915 and 1917. The abandoned property law, perceived as normal and ordinary laws in Turkey. Their existence has never been questioned in this connection. Their consideration as natural is also an answer to the why the Armenian genocide was ignored throughout the history of the Republic. This normality is equivalent to the consideration of a question as non-existent. Turkey is founded on the transformation of a presence, Christians in general, Armenian in particular, into an absence. The Turkish Republic is a construction based on the transformation of the state of existence of the Christians to one of absence, or in other words, on the negation of an existence. This is the reason why the topic, which is called Armenian question in Turkey, basically is discussed as a national security issue there. Bringing up this topic, or even just calling for an open discussion of it, is perceived as a threat to national existence and national security. For example, the Turkish National Security Council in 2006, finding the transfer of land records covering the 1915 period to archives, Prime Ministry archives actually, and their presentation for the use of researchers to be contrary to national security and prohibited. The truth revealed by this is very simple. Because Turkey founded its existence on the absence of the other, every conversation on its existence inspires fear and anxiety. The chief difficulty in speaking on the Armenian issue in Turkey lies in this existence and absence dilemma. Raphael Lemkin introduced the concept of genocide for the first time in 1944 in his book, entitled Axis Rule in Occupied Europe. The book consists of a compilation of 334 laws, decrees, and regulations connected with the administration of 17 different regions and stayed under Nazi occupation between March 1918 and November 1942. That is to say that Lemkin did not introduce the concept of genocide together with the barbaric practices like torture, oppression, burning, destruction, and mass killing observed in all genocides, but through a book quoting and analyzing legal texts. Could that be a coincidence? Given its importance, it's necessary to stress this one more time. In the year that Lemkin completed the writing of his book in 1943, he already knew of all the crimes perpetrated by the Nazi Germany. However, he did not present the concept of genocide in a framework elucidated by these crimes. On the contrary, he introduced it through some laws and decrees which were published on how to administer occupied territories and which perhaps in the logic of war might be considered normal. We cannot say that this situation accords well with our present way of understanding the genocide. In the general perception, genocide is the collapse of a normally functional legal system. It is the product of the deviation of the system from the normal path. According to this point of view, genocide means the institutions of civilization are not working and are replaced by barbarism. Lemkin, however, seems to be saying the complete opposite of this. That genocide is hidden in ordinary legal text. By doing this, it is as if he is telling us not to look for the traces of genocide, not only as barbaric manifestations, which can be defined as inhuman for sure, but to follow their trail in legal text. In the same way, Armenian genocide does not just exist in the displays of barbarity carried out against Armenians, it is at the same time hidden in a series of ordinary legal texts. What I wish to say is that genocide does not only mean physical annihilation. What is important is the complete erasure of the traces of the Armenians in their ancient homeland. Interior Minister Talat Pasha, in April 13, 1916, telegram sent to the governor of Syria, Jamal Pasha, and the commander of the Fourth Army, in connection with the Armenian church in Sis, is the clearest expression of this policy. Quote, basically, the goal of the abolition of Sis Catholicate, and at the first opportunity, the expulsion of the Catholicos from there, aim at completely removing the existence of this place, which possesses a very great historical and national value in Cilicia for Armenians, and is presented by them as supposedly the final seat of an Armenian government. Unquote. Law exists for this purpose, and in Talat Pasha's expression, everything was arranged in a very suitable way for completely removing the existence of the Armenians. In this understanding, genocide is not a deviation from the normal operative legal system. It is in itself a product of the legal system and has been implemented by means of this system in question. Hasan Fehmi Bey, the first secretary of the Treasury of the Turkish Republic, in April 15, 1923, while discussing the new abandoned property law. The new abandoned property law means the first abandoned property law promulgated in the Republican era was 15 of April 1923. It was the first abandoned property law of the Turkish Republic. Spoke out, splitting a hair into 40 in legal theory, and said, it has been 2 or 3 years since we here set out to take into consideration the law of abandoned property as one of the most delicate and fine points of our legal basis. Through these words, he demonstrated the extremely crucial relationship between the law and the regime of genocide. So, actually, it is necessary to mention several elements particular to the Armenian genocide in connection with the confiscation of Armenian property. First, the only group of people whose goods and property were being subject to, both immovable and movable property, by the way, being subject to liquidation in the 1913 to 1918 period was the Armenians who were being deported. The property of the Armenians who were not being deported was not confiscated. In various telegrams sent to the provinces, it was specifically specified that only the goods of people being expelled should be liquidated. Quote, the non-Muslims who are not being transported continue to possess their movable and immovable property. The property of Armenians being transported and the other non-Muslims who were being deported together with them at the same time it's subject to liquidation. Unquote. In addition, if Armenians who stayed in the places where they were located and were not deported had property in other regions, those property were not touched either. This occurred, for example, with Armenians living in Istanbul. Second, because the confiscation of the Armenian property did not take place on the basis of a racist ideology, unlike the case of the Jews in Nazi Germany, no discussion of lifting the citizenship of the Ottoman Armenians took place during the deportation and genocide. Moreover, if Armenians were not removed from citizenship specifically by a decision of the Council of Ministers or through their own individual resignations, their citizenship was preserved until as late as 1964. Thirdly, while the material wealth of the Armenians was being seized, it did not take place in the form of confiscation. That is, it was not said that the goods or their equivalent values would not be returned to their owners. On the contrary, everything, the goods and their value will be administered by the state in the name of their owners, and everything was organized according to the principle that the goods or their equivalent worth will be returned to their true owners. Although when this would actually occur was uncertain. The choice of this path was due to the manner of the organization of the genocide and its ideological justifications. But this characteristics was not suitable for explaining the need for confiscation of the goods. However, on the other hand, the forcible seizure of goods, not in the form of confiscation, but through preservation of the rights of Armenians to their ownership, created internal tension and contradiction. The state accepted that the true owners of the properties taken were the Armenians and adopted the principle that their equivalent values will be given to the latter. The tension or contradiction lies here. On the one hand, there is a state which does not wish to be accused of usurping goods by force, and the language of abundant property law was set accordingly. However, on the other hand, the same state wished to destroy the basis of the existence of the Armenians and institutionalize and render official seizure. The present legal system was founded upon this tension and contradiction. The law was used in the dual manner for the removal of the economic foundations of the survival of the Armenians. First, in 1915, the Armenians were legally forbidden any sort of right of disposal over the goods they left behind. Second, although the law formally granted them the right to the value of their property, not a single step was taken to reimburse them. None of the promised laws and regulations were issued. In an entire period of the Ottoman Empire and the Republic of Turkey, the laws and the decrees issued in connection with abundant property were intertwined with the principle of the goods and their values being given back to the Armenians. However, on the other hand, this procedure of restitution was not arranged in any manner, and the same legal system was used according to the principle of not giving the Armenians even a single inch. Especially in the Republican period, in the rare case when some Armenians who somehow survived or their heirs were able to ask for their property or their equivalent values, they only got lost in the corridors and the passages of the existing legal system. The Committee of Union and Progress Government was aware that this was the situation too. I mean, the situation is that the abundant property laws and the decrees basically do not deny the rights of the Armenians to their property. So, I want to quote here a report which was issued in February 1918 by Enver Pasha, stressed that the rights of the Armenians to their properties remain. This historic report states that, quote, although the Armenian abundant property was invested with a legal status, while the payment to the owners of the value of the property transferred to the treasury of pious foundations and the treasury required by law is necessary, until now it was not able to be given. In other words, it was openly accepted that up until that day, the value of the Armenian property had not been paid to their original owners. according to this report in February 1980. When it was stated in this historic report that though the Armenian abandoned property has been designated for legal liquidation and while as required by law, the remittance of the equivalent values is required to be given to the owners of the properties, transferred to the Pious Foundation's treasury, and the treasury, they are not being given until now. It was clearly accepted that the equivalent values of Armenian property had not been given until that day. Furthermore, the elimination of the right of ownership for people whose property is subject to liquidation, also in accordance with the provisions of the aforementioned law, being conditional on the payment of their equivalent values as required by law, and while the aforementioned properties are being impounded as it will not be suitable not to take into consideration the rights of the owners. The language of this report is extremely clear. By February 1918, the equivalent value of the Armenian properties had not been given to them. The report asked that the requirements of the law be fulfilled as quickly as possible, and that with the rights of the property owners being taken into consideration, the equivalent value of these properties be given to them. Similar views were expressed by the Turkish government during the Lausanne negotiations, when it was learned in Lausanne that another abandoned property law has been issued on April 15, 1923. The victorious Allied powers of World War I, especially Great Britain and France, forcefully protested this law, particularly because it was applicable to their own citizens, Ottoman Armenians, who were nationalized by Allied powers before the World War I. İsmet Pasha, who reported the situation to Ankara on 22nd of June, received the following response, which must be considered one of historical importance on 26th of June. Quote, in the abandoned property law, prepared and put into effect by the Turkish Grand National Assembly, our government's sole point of consideration being directed toward the protection of citizens' assets and the law for the purpose of the protection from the damage of the abandoned property of those fleeing or absent, their sums are to be registered in their own current accounts. And in this respect, whatever is required for the safeguarding of the laws will also be assured. As has been seen, the government again repeated that the true owners of the property is the Armenians, in order that the goods and the possessions of the citizens of the state do not get destroyed. It took them for protection, registering in their names. In order to understand how the abandoned property law and laws and decrees were constructed as an important part of the genocide, it is necessary to study them on three different features. First, according to which principles were the Armenians going to be so-called settled in the new places to which they were deported? Second, were the goods they left behind or their equivalent values given to them? And if they were indeed returned, how did this take place? Third, who used the property which was left behind and how? When we examine the laws and decrees concerning these three different aspects, we are confronted with an interesting picture. For the first aspect, that is the topic of how the Armenians were going to be settled in their new localities, the laws and decrees almost do not play any role. This was dealt with only in one degree issued at the very beginning of the deportations in an extremely limited manner, while in later laws and decrees it was not mentioned at all. It was as if such an issue didn't exist. As for the second issue, a general principle was only repeated several times, that's all. It was accepted that, again, the true owners of the properties were the Armenians, and the state was administering these properties in their names. However, when and how these properties or their equivalent values will be given to their true owners was not discussed in any way, and no arrangement was going to be made concerning this issue. The absence at the first two levels shows us something. The Ittihadis, in their mental work and practical policies, considered that the Armenians, from the moment they were deported from their homes, ceased to exist. And making any sort of arrangements for a community considered non-exist was redundant. With such attributes, These extant laws are the best evidence to rebut the official Turkish state thesis concerning the Armenian deportation. According to the official thesis, the aim of the Armenian deportations was to settle the Armenians in a new region and to give the equivalent value of the goods left behind to them. If there were such a goal, then there also exist laws and regulations appropriate to it. Indeed, the February 1918 report cited above openly accepted that the equivalent value of the goods was not given and no arrangement has been made in this regard. A similar situation existed for the period of the Republic. Of course, issues at the first level concerning the so-called relocation of Armenians were absent. The Armenians had been to a great degree exterminated. Those surviving, if not assimilated in Anatolia, remained outside of the borders of the new state. As far as the second level of the issues was concerned, the laws and decrees issued were like those of the Ittihadist period, repeating the same general rule. The true owners of the properties were Armenians. The properties of their equivalent values will be given back to the latter. The state was administering these properties or revenues in their names only because of the absence of Armenians. Nevertheless, in order to be able to give back the goods, the Armenians had to be present together with their properties as of August 6, 1924, when the Lausanne Treaty was enforced and approved in the Turkish parliament. This was the principle accepted in the Lausanne Treaty. From Turkey's point of view, the serious problem was what would happen if surviving Armenians wanted to return or if their heirs tried to ask for their goods back. This was the fundamental issue that had to be solved in the Republican period and the theme of the greatest test and so-called success of the legal system that was being created. In order to prevent the Armenians from taking back their belongings, an elaborate legal system was formed with all the details throughout and any holes or gaps coming to the view filled in, similar to the refinement of a silkworm spinning its cocoon. It's a famous Turkish saying, İpek böceğinin kozasını örmesi.
The way the
refinement of a silkworm spinning its cocoon. The biggest goal of this system was to erect a barricade in front of the Armenians who might enter the country en masse or as individuals and demand their properties. There were some situations where it will be impossible to prevent their entry legally. In these instances, there was no hesitation in transgressing the law. The internal tension and contradiction of laws and the decrees could be observed throughout the Republican period. While the first two levels to be studied are absent, the main topic of the laws and decrees of the Ottoman and the Republican eras is connected with the third level. That is, how will the Armenian movable and immovable properties left behind be liquidated? If they are sold, how will they be sold? If they are to be distributed, to whom and according to the which rules will they be distributed and how should they be registered? The primary goal of the laws and decrees is by seizing all the movable and immovable property of Armenians to eliminate the physical foundations of the Armenian existence in Anatolia. Thus, the removal of the physical and cultural existence of Armenians is inherent to the Turkish legal system. This is why I'll call this system as a genocidal regime. The secret of the Turkey's following such an aggressive policy of the genocide denial, both domestically and internationally, lies in the realities related above. The Turkish state knows that it is very difficult to prevent the return of Armenians' goods through the logic of the existing legal system. If it says that these properties do not belong to Armenians and will not be returned, it will have accepted that a crime was committed. It will be forced to accept the fact of their seizure because not a single cent was paid in exchange for the Armenian goods. This aside, the abandoned property laws already constitute a crime according to the existing Turkish constitution. According to the principles of international law, they are a clear violation of human rights. On the other hand, if Turkey says that the owners of the properties are the Armenians, the way will have been opened for the goods or their equivalent value to be returned to their owners. Unable to say either of the above alternatives openly, only one choice remained: stubborn and taking an aggressive stance on this topic. Putting aside the fact that Armenian properties were seized by force and plundered, the law is a face-reddening moral crime, and Turkey is aggressive because it knows that it committed this offense. No matter what type of legal interpretation is carried out concerning this topic, I believe that in the end, it's not only a legal question but also a moral one. The topic we are confronting is very simple one. As Ahmet Rıza, who was a very vociferous CUP member and one of the founders of the Union and Progress organization, not a party at that time, and Ahmet Rıza also was the president of the second parliament, Ayan Meclisi, Ayan Parliament in Istanbul at that time. He said in December 1915 in the parliament, when the abandoned properties law were being discussed in the Ottoman parliament, the essence of the matter, quote, is an oppression. He continued, hold me by my arm, throw me out of my village, then sell my goods and property later. This is not lawful at any period of time. Neither Ottoman conscience or law accept this. Ahmet Rıza Bey rightly said that the goal of this law was the completion of the plunder as soon as possible. He added, the goods of the Armenians were partially plundered, nothing will be left by the time the legislative power rejects the law. Indeed, it took place. Thank you so much.
Edvin is another just incredibly talented and accomplished individual that we're so fortunate to have here. Among other things, and I don't know exactly what this means if you have a cape or not, but he's a super lawyer in California, which is, I assume, a pretty significant thing. So he's considered, a top lawyer in California, which is the size of many countries in the world. So it's pretty impressive, and we're really fortunate to have you here to share your insights, following up particularly on what you shared with us. So thank you so much.
Thank you for organizing, thank you for inviting. It's been great. Like said, the morning panels are excellent. Pleasure to be here. So I'm going to try to approach in a way what Umit talked about from a lawyer's standpoint. At the end of the day, justice is, where we at least practice it in the West, we try to get it in a courthouse. So how do we convert, and I think I made a note here, and Tom said, how do we convert the endless workshop into some sort of a justice remedy, if possible, in a court of law, or from a judge? Standing, where do we go? Which court? Is there a court available for Armenians to go to today? That's been covered generally. I'll try to approach it as much as I can by sort of presenting myself as some lawyer who sits in his office like your local lawyer, and you go to with a deed in your hand. The deed says, you own property, your grandfathers and grandmothers before 1915. You own tons of land, Dikran there, Malat there. Can you help me? And of course, all the other remedies, and and I'll start with that. Or you had a life insurance policy that was sold, premiums collected, it's property, and you say, can I collect on this? And various other topics. So, what do I do? Okay, I'm going to say, what do I do with this? Because many people come to me with major legal grievances, and they've been wrong. They've been wrong with employment, they've been wrong with personal lives, and they have real grievances. But unfortunately, even our legal system in the United States or in the West cannot compensate for every wrongdoing. You have to have a cause of action, you have to have jurisdiction, you have to have the right court that's authorized to grant you your justice. Otherwise, you're not going to get justice even though you're entitled to it. And that's, what we as lawyers are used to this. We tell this to our clients. We have clients who are all gung-ho, and we are good at sort of calming them down and having them see reality. It's much harder when it's your own people. It's much harder when it's at the scale of genocide. But so let's start with the United States. Where do we stand as far as legal remedies? Can we go to a court as Armenians and claim our rights? I think this was best highlighted, and my pessimistic attitude will be based on the most recent decision that involved the life insurance case of Minassian, also known as Armenian versus Intl, which is a German life insurance company that went all the way up. Even the Supreme Court rejected the claim. I'm sure most of you are familiar. I'm not going to bore you with the details. What is relevant to us today is the way that case progressed and the California law, which granted Armenians and others, and that's very significant, the right to obtain benefits from somebody who collected premiums from their grandparents. Was challenged before the federal courts. And they said, California, you got no business in this. This is a federal matter. The United States government has something called foreign policy. And their foreign policy, they decide they're going to be nice to Turkey. So we don't want any of this because it's interfering with the executive's domain in foreign affairs. Even though initially the case was won, it went all the way up. Ninth Circuit, which is one below the Supreme Court, and back, which means all the judges. Usually 3 judges sit. In this case, they had 11 of them, all over the western United States. And they made a unanimous ruling that, no, this indeed not only conflicted with, but also it entered the entire domain, the field, and therefore it's preempted. And what's, again, relevant to us, and what was shocking, was until that moment, until even the Ninth Circuit issued a ruling, the administration was silent. They didn't say anything, even though the German company was claiming the federal government doesn't like this. They had not spoken. This was only spoken for them by a private party. But the Supreme Court asked and forced their hand, asked for an opinion by the administration. So, Solicitor General, who represents the President, wrote an opinion. And that was something that, those involved did not expect at all, to go that far. They went beyond what the court had done. And also the statement, interestingly, it wasn't only signed by the Solicitor General, but also signed by the State Department. It's a joint signature submission to the Supreme Court saying, don't allow, cancel, basically, invalidate the law that California has on the grounds that, it intrudes on foreign affairs, conflict, field presumption, all that. But more importantly, they referenced a bunch of treaties. And they presented that to be valid. And, in other words, they made, in my opinion at least, I could be wrong, inaccurate representations. One of them was that the United States had already resolved the claims of Armenians under the very little known Lausanne II, which was a Lausanne treaty between the United States and Turkey. And if you, number one, that treaty is not valid law because it was never ratified by the Senate. It was in fact rejected by the Senate. And a little bubble on the side without digressing too much. And one of the primary reasons given as to the rejection by the Senate was that the Wilson arbitration was not adhered to. So that means they even recognized, in essence, by 1927-28, that that was something still important. But second thing was that even that treaty was valid, even though it was not valid. It only dealt with the rights of United States citizens, Armenians who were U.S. citizens before 1914. So it could not even have affected U.S. citizens, those Armenians who had become U.S. citizens subsequently. And they are the ones who lost their properties to begin with and subjected to genocide. So, and they also referenced this U.S.-Turkey Claims Agreement of October 25, 1934. Again, that really did not deal with the Armenians who had been dispossessed through the genocide. That most of that money, if I'm not mistaken, 1.3 million, I think, most of it was paid to missionary organizations for the cost that they have incurred in assisting Armenians. But again, it's amazing. And then the final thing, and that also, the third major misrepresentation was the law itself, because they argued that we need to determine whether or not there is a genocide. And that's very important because of the psyche of judges. When we talk about going to courts, obviously, who are we going to? A judge. And judges don't like politics. I know lawyers know this. You want to stay on the law, and you want to stay away from politics, because they always say that's not my domain. And I remember vividly at the Ninth Circuit argument, the oral arguments in this ornate courthouse in San Francisco, one of the justices, from Idaho, I think, he asked directly, he said, are you asking us to have our federal district judges that make a factual finding of there is a genocide or not? And I don't know, the answer was good enough. It should have been no, because the law did not say you must make a finding of the existence of a genocide to reimburse these people for their claims. It specifically said, and this Solicitor General misquoted it, it said that you need to make a finding that there is this is for Armenian genocide victims only. But they omitted the next paragraph, which defines Armenian genocide victim, which says Armenians or those of other ancestry, not just Armenians, of other ancestry, who died or were deported or were killed or escaped to avoid prosecution. In other words, you could have died in your bed in Harper if you had a life insurance policy, nothing to do with the genocide. You could be a Kurd who owned the policy. Under this law, you could still have recovered. But the government, in its zeal to shut the door, they went so far as to make those cuts. But basically, my point is, in my opinion, and I could be wrong, other lawyers may think otherwise, unless our political arm works, and unless we Armenians as a society get together and change legislation or influence the administration, our third branch, Article 3, our courts are not available for any kind of genocide-related reparations at this point in time, based on my reading of this case and the federal government's position. Now, my second area will be, so where else do we go? I think Tom mentioned the international courts, tribunals, they're about personal crimes. Genocide is a crime. Talat, Enver, and the rest of them are not alive. I don't know who to persecute, and that's not up to individuals anyway. We as lawyers, again, remember my client with the deed. What do I do? Maybe Turkey. So, and as Umit said, there was an incredibly sophisticated series of laws passed to make that impossible. In other words, from day one, you can recognize the sophistication. Turks who are called barbarians and this and that. The sophistication of how they set it up, even until today, how it's almost impossible to go to court and say, look, I was a citizen. You came to my house, you told me I'm an enemy collaborator, and you said you're going to relocate me somewhere else. To my property, you made an inventory, and on the way, you killed 80–90% of us. But then, what you claimed was my property, you were holding in trust, and you give it back to me once the hostilities were over, became abandoned property. So trusteeship turns into abandonment. And of course, relocation turns into exile. And what happened? How was this done? I mean, we don't have enough time. But basically, the law on abandoned properties is very important because they made very, very clear that there was a bare essence of trusteeship left. In other words, the government was always acting on behalf of the individual family that they seized the property from. They never let that go. It might let go I'll try to touch on that soon. And to prevent, of course, there were treaties, the pressure from all the foreign entities, France, England, United States. What do? They never removed the citizenship of the individual Armenians whose properties that they seized. That's also very important. Why is that important? Because they don't want them to come to Turkey as a pure American citizen, or as a pure French citizen, or as a pure British citizen, and claim the property. They can tell them, you're my citizen, you don't even get to go in. Or I'll arrest you. Or in other words, they wanted to maintain jurisdiction over the individual as a citizen. And that's very, very important. That was, in fact, let go only in 1964, as Umit mentioned, when the Greeks were being, one of the major crimes against Greeks was occurring. As part of that, when they said any Greek who was also a Greek citizen was deported, they were given 24 hours and a little bag to take out. That year, those Armenians were also removed from Turkish citizenship. So, but the original masterminds wanted to maintain that, and that's the reason Lausanne Treaty, which talks about time limits of individuals having the right to come back, which can be used because Lausanne Treaty is law in Turkey. So, therefore, it's Turkish law. You can use the Lausanne Treaty to go to court and say, based on these provisions, I have a right. But what will they say? Well, you have 2 years, 1926 or something, and by 1928, your time expired. And also, of course, they didn't allow any powers of attorney or anyone else. It had to be the same individual who owned the property. So even, how could the orphan, even they could go? Well, because the father and mother, they were all dead. How about the several women who were taken into slavery, who were taken as wives by a lot of, chiefs, Kurdish tribes and others. So, on top of it, Armenians were actively prevented. Like Lebanese Christians were coming back and claiming their property because those from the so, one key thing we as lawyers think there, and that might be the opening, and I have little time left, is that conduct, preventing Armenians from coming back. That's why it's very important. Everybody should study that very well, is arguably estoppel. In other words, the time limit is an affirmative defense. It's something that is allowed to you as a technicality against someone who actually has a right. So they can argue that in court, maybe in Turkey. I doubt that it will be successful. But again, Turkish court, remember, you get to appeal to European Court of Human Rights. So even if these cases are lost in Turkey, they should be brought and set up the right way, properly, by the right lawyers. There's a lot of lawyers out there who are Turkish lawyers making a bunch of claims. Be very careful. And also, I'm concerned that, as long as we have these abandoned property laws, there's the opening, and based on earlier conversation, I'll end on that note. I'm concerned that this new Turkish-Kurdish process going on, the peace process, may lead to adoption of certain laws, and maybe one of those laws will be the repeal of the abandoned property law. Why? Because I don't think the Kurds will not want to compensate the Armenians. They will not want to become the trustees of these, the properties. So that's something to watch for. And with all the support and all the niceties and all the confessions that their grandfathers have done wrong, I think the Kurdish leaders need to also address this. What is their position on the property owned, taken from Armenians? And I think my time is up, so thank you.
Another really fascinating presentation. So we have some time left, and we're probably going to try to steal, if we're okay, maybe a few minutes since we started a little late, for questions. And I'd like to just ask everyone, because I'm sure there's a lot of questions, so if you just keep it to a very brief question, and we'll just go in turn. So you had your hand up first?
I have a very specific question. This is Armenian. Your point was fascinating. I've never considered this concept of before official recognition, possibility of reparations. I mean, in my mind, if you're giving back something for reparations, you must have at least admitted to yourself that you are responsible for the crime. Could you elaborate maybe like a possible, like a realm in which, like what could happen in the next 10
Well,
years?
there's more than one crime, right? There's the crime of genocide, but the deprivation of property and life is separate from that. The crime of genocide is a state act to eliminate a whole nation or ethnic group. But at the same time, there was deprivation of property that was confiscated without any compensation. That in itself is a separate actionable event and a violation of human rights as well. So that would be the basis for it.
Great. Okay. Yeah, you're all set? Okay. Yeah.
Edvin, I mean, to a certain extent, for those of us that are laymen and not attorneys, we get frustrated by the talk of limitations, of all the limitations that exist. And we look to our experts to think outside of the box and come up with novel and different ways of approaching a problem instead of always pointing out the limitations that the law has in place, because laws can be changed to make it easier, laws that once existed. But I'm curious, you concentrated on the United States. What about other countries where if the United States process doesn't work, are there other countries where we would have more success because of their legal system, because of their government? There are Armenian genocide survivors around the world in every country of the world. If there's another country that we should approach it in, and leave the United States to be a laggard in this, then let it be so, and let us go to these other countries. Can you point those out? And the other thing I would ask is, maybe you know this, is I always hear talk of these very detailed, meticulous records kept about every property. I've never seen any record of such property. Okay, there's no evidence that it's ever been done.
Well, I'll answer and then, I can answer that. You know the answer to that question. Well, I wish I was an expert on German law or French law, but of course I hear you. And, don't think that, when we have the lawyer hat on, we have to look at reality. We do find, I think going to Turkey and filing lawsuits there is not an easy task. I think that's the right place to start, because all the others indirectly are involved in it because of what I just said. Because on that European Court of Human Rights, there'll be a German judge sitting, presumably. There'll be a French judge sitting. And it might be easier for them, right, to do the right thing, as opposed to sitting as a judge in Berlin. And you go to a Berlin court as an Armenian and try to, I don't know what you would claim. You could claim what? I guess Germany was an aider and abettor, and therefore is responsible, probably. But I must think that there are a lot of smart Armenians living in Europe or in Argentina, and they've done a few good things there. And for some reason they haven't succeeded. From what I know, France and Italy have had special treaties with Turkey that sort of closed the door, but I could be wrong. To me, the most culpable country is Germany, based on my historical knowledge, as an amateur historian, not as a lawyer. So, like this life insurance, what I kept asking, why are we suing a German insurance company who sold life insurance in Anatolia to Armenians in a court in Los Angeles? Why aren't they sued in Germany? It's a German company. They targeted Armenians. It's too much time, but you should know they targeted Armenians specifically. Because as part of discovery, we got records of the training manuals for salesmen. And they said, go after Armenians because Armenians have a more logical and rational relationship with death, and therefore they'll provide for their families. So they make better customers than the Muslims, the Jews, and the Greeks. And they were specifically targeted. So, but I'm sure it's statute of limitations. In California, we had to change the law to give time.
Somehow answer your question. Lausanne Treaty matters a lot. Actually, negotiations within Lausanne before the official declaration of Lausanne in the Turkish parliament as well, matters a lot. First, I gave some quote from İsmet Pasha because Turkish Republic actually promulgated a new law, which was called a new abandoned property law, and it was promulgated in April 1922. When the France, Great Britain, and other, allied powers within the Lausanne negotiation heard that, they were so frustrated and made some complaints to İsmet Pasha in order to claim, in order to just, present their complaints, because these laws paved the way for the Turkish politicians or the bureaucrats to keep confiscating the Armenian property. After that of the Lausanne Treaty, Lausanne clearly, openly stipulated that Armenians who were nationalized by France, Britain, or the United States, who managed to come back to Turkey within these 2 years, and who should just stand in front of his or her property will be given back to them. What the Turkish Republic did, they promulgated passport laws, they promulgated a travel law, and they also, and by means of that, they didn't let Armenians who came from France, Britain, or the United States get into country. They didn't let them. And for businessmen, for instance, they managed to come in, get into Turkey, and they managed to get their properties back according to the stipulation of Lausanne, because they got this right from Lausanne on the basis of Lausanne. And this issue just exploded within the parliament, and the interior minister of Turkish Republic at that time was forced to resign.
But there was another question. I think he asked.
Another question. So, I have been in Turkey for a year, as you know. I have been conducting research in various archives, and I spent 6 months almost in Prime Ministry Archive in Istanbul and the Republican Archive in Ankara. And I asked approximately 14 or 15 times to get the records of Liquidation Commission, which was established in September 1915, and the Abandoned Property Commission, which was founded up in June 1950. They told me that first and foremost there was a sharp silence for a second, and then I got the answer that we have not cataloged or classified those documents yet. So since we haven't cataloged such kind of document, I'm not allowed to talk about it. So which means, and then I retorted that, which means you saw those documents, and then the archivist kept inside. He didn't tell me.
1 minute.
Please.
On that, because it's very important that these records, property records, that are 100 years old, are classified as top national security matters. It's probably one of the only countries in the world who classifies 100-year-old property records as top secret national security documents, and that's one of the reasons that I think a lawsuit in Turkey makes more sense, because the first thing I would do before you even go to trial is ask for a discovery order, ask the judge to order to open those archives. Because if I'm filing a lawsuit, I have some proof that I own property there. Now I want these archives off. Of course, they'll reject it, but that's going to make another legal issue in addition to the justice.
Just so you know, they shipped those records to Palestine for Palestinians searching for property rights in Israel based on Ottoman times, so they do exist and have been used.
But the Armenians on the seal, right?
The records of liquidation commissions, I'm talking about 35 liquidation commissions, by the way, in 35 different provinces in Anatolia. One of them is Intl, and I am working on Intl, and I asked for the records of the liquidation commission in Intl, and the answer was, we haven't cataloged them yet, which means, so there are records over there, so they are available, physically available.
You had something to add, Tom?
Two quick things. One, there is a sleeper of a law, the Foreign Tort Claims Act in the United States. Seems possible to think about how to use that. It has been used effectively in similar human rights situations. But there is a statute of limitations issue, which again is a matter of, as you suggest, getting some legislation through. Maybe instead of asking for recognition, we should assess the statute of limitations to be extended. Another thing, another possibility would be to ask for a multilateral commission of some sort that had arbitral powers to both hear all the claims and also to adjudicate finally as a matter of legal fact as opposed to the court of public opinion, the genocide issue. if everyone's so sure it didn't exist, there shouldn't be any problem. If it really is, then we should know the truth, right? That's a better ask than maybe it's a way for the president to sidestep the Pentagon and the State Department to take that route, right? One other thing, as far as church properties go, there are lots of documents, and the church has them. So there are original documents there, and there's a 1912 inventory that is well known.
You've been very patient over here. Go ahead.
With regards to the other ethnicities that suffered during the Ottoman Empire, are there any other reparation efforts taking place to other cultural groups that you know of, and are we working with them? Is there any unilateral approach there?
For Assyrians, yes, we have. Assyrians have some claims for reparation. This is a current issue actually. Syrians. For Greek, there was a population exchange treaty in 1923, so this reparation issue was also resolved in this treaty as well.
Thank you. Who will speak for the Armenians, I guess? How do we come to a consensus to have one voice for the ask for repatriation? Because there's a lack of unity, and how do we get to unity, or how do we get to one voice?
This is a good question. I think that this is up to the leadership of the community, but I think the first place is that scholars can start begin to propose different kinds of, and other public advocates can begin to put out what they think are reasonable claims and support them as best they can. And organizations are doing it, like Armenian Bar Association.
But we can't that perfectly animate the group. There will never be anybody who will speak for all the Armenians.
Right.
And we will only, you can only speak for so many, even if you get so many together. And like I said, if there's not a lawsuit or some sort of a compensation scheme, individuals can be told you don't have to be part of it. But if you want to be part of it, just like the 9/11 resolution, that's the best we can do. Yeah, you can come, be part of this. If you want to go sue, go ahead and do it on your own. So, because otherwise you'll always be accused of speaking for people you don't speak for.
Finally, the state espousal. We know the state, and our state can espouse our claims, and it has standing in the world community to do so.
I want to ask, it might not be very realistic, but if Turkey should join the EU, will that change the Armenian cause?
Well, legally, their laws are supposed to be compatible with the European Union as we speak. In other words, because they're a candidate. For example, they have genocide in their penal code as a part. The same genocide that's in the UN Charter is, I think, Penal Code 79. So legally, there may be, of course, the discrimination then, that exists. I don't think they could, the unofficial discrimination that goes on, the unofficial acts that go on, I would think, but that's more political than legal, I think, change. But it would be good news as far as I'm concerned. I believe, we would be in a better position as Armenians. Maybe we'll get road signs that say Western Armenia, if they're part of the EU, then you are around one. Or Peter.
Could any of you explain what it would mean to actually return the churches to the Armenian church? There's been a call for this in the Congressional Resolution, this has been in the press. How would that work? How does it happen?
You mean physically, or you mean?
Well, in other words,
legally?
So let's say the Turkish government said, well, okay, you can have your various monuments, ruins, functioning churches, then what? What does it mean that citizens from around the world are allowed to go there, or that is there any physical plant restoration? What is it?
First of all, I think that should not be the subject of a lawsuit. An Armenian church obviously belongs to the Armenian church, right? A church. So, and I think that the title's always said, by the way, the owner of the churches usually marry the mother of God. That's what it said on the actual title. So, your real question is, first of all, I would say, I mean, that should be up to the Armenian people. Who the Armenian people are, we can argue about it. It is, but first of all, I mean, it's not up to Turkey or anybody else. It's our church. Let the Armenian people decide. That it is useless, useful, I don't know. But I think that, you know, if, for example, it goes to, depends on, does it go to the Patriarchate in Istanbul? Does it go to the Catholicosate in, you know, Antilles? Some belong to Antilles, some belong. I think Armenians can get together and come up with a lot of creative stuff. I don't have time, but I can think of like Spain or Italy. You could have a lot of cultural centers, turn these buildings into Armenian cultural centers of the region that they're sitting in, make them like a bed and breakfast, museums and all that. I mean, that's just what I'm going over tangent. I'll let Tom say.
That's it. There's 3 or 4 different things to say. First, there are the churches that are still intact. Those clearly could become the property of the church and be reconsecrated and maintained as churches, assuming that the church wants to do that. Number 2, those that have been destroyed, but they're still titled to them, there's compensation due. 3, there's a lot more than churches involved. There's a lot of land. The largest landowner among the Armenians was the church. So there's a lot of money you can pay to the church. Now what the church does with that money, if it gets it, is a separate issue. Presumably will use it for the benefit of the Armenian people. Finally, this is not something that the church really should have to sue for. I agree with Edwin, because under existing international law, the Turkish government is obliged to allow full access to the churches and all of our sites as a matter of cultural heritage, which they have been flagging for decades. So most of what the Armenians want, the Turks already owe us as a matter of international law. These are not new asks. This is just asking them to start to behave like reasonable, law-abiding members of the Community of Nations, which they haven't been.
For all this to happen, there needs to be cooperation from Ankara. Ankara has to cooperate, otherwise this would become, the obstacles here would be many. And that's, I guess, part of my question. How does that work out, and who works it out, really? Who shepherds that? Is that Yerevan? Is that Washington? Is it Paris? I don't know.
That's the beauty of a law case. Courts allow individuals or small groups actually to stand up to governments. And so I think it can be forced. And the one case I think that's a pretty hard case for them to deny is the church claims. So let's see what happens with the church claims. Individuals they can push around, I think they're going to have more problem pushing around the church. We'll see.
There you go.
Where New York Life Insurance was sued, and they paid, as well as a French insurance company. How was it the German insurance company?
They made a business decision. I mean, on the surface, I mean, at least what we know is it was a business decision. And don't think, I mean, what New York Life and the other company paid were what's called nuisance value. I mean, compared to what they owed, the amount of money was a very, very minor percentage of their exposure. They just decided not to spend money on lawyers and all that, and they settled.
It's not binding for Turkey, it's the problem.
Right.
You get compensation from the insurance company itself, not the Turkish state as an official entity, because these insurance policies were confiscated by the Ottoman government itself, rather than by the insurance company. So you cannot open a lawsuit against the government in order to get compensation for appropriation of these insurance companies, for instance.
But they still were involved. Of course, the law firm that represented the German insurance company is a major lobbying forum for the Turkish government. They're the law firm that helps them get bonds issued and all that stuff.
And what I mean is the crux of the issue is to condemn the state, Turkish state itself. That's the issue.
The paranoia.
Way in the back.
This is an issue that's come up in different ways, but I was just wondering if you think our platform is weakened by the fact that the issues that we say pick a side on, like the reparation or whatever, if those weakened by the fact that we're not consistent about those issues across the board. Like, for example, I feel like Armenian voices are not heard when it comes to issues that plague our American society or the issue of reparations for Native American lands off the top of my head. So I'm just wondering if you think our voices are kind of deaf or like they fall on deaf ears when we kind of, I know we're supposed to be our own advocates, but I don't see how we can advocate us 100% and we're only advocating for us and we're kind of hypocrites when it comes to other minorities or other marginalized people's issues. Does that make sense? So I'm just,
No, you're absolutely right, and I think and only today, usually because I learned this from a lawyer that I respect very much, Armenian lawyer, David Balavanian, who was involved in this. And since he said it at a meeting like this, and I've always said it, but today because of my time limits I forgot. His usual opening is, let's not forget, we're probably sitting on, as we speak, on Native American land that has not been compensated for. And then go on. So we do. But I think you are right. We can do a lot more, but I can go on and give you a few examples of what Armenians have done for this civil rights cause and that, but it should be more, I agree.
I also wanted to just throw out a reference to the Armenian Review, which Dick Collegian is one of the editors of, did a special issue a couple of years ago on the global reparations movement that included a whole range of issues, South Africa, African American, comfort women, and so forth, and was really trying to enact the exact thing that you're talking about. I mean, to talk about global debt, Haiti, I mean, just a whole range of issues. You're absolutely right. You've been waiting patiently, so please jump in.
So I just wanted to mention, this morning I found out as I was Googling something else, is that since Saddam was toppled, Iraq actually paid out several $1 million in reparations to the United Nations Compensation Commission, which is a Geneva-based quasi-tribunal that assesses claims and disperses awards. 37 million went to the United Kingdom and 32.8 million went to the United States, and guess what? The majority of the compensations went to private corporations such as Halliburton, 18 million, Bechtel, 7 million, Mobile, Shell, Nestle, Pepsi, Phillips Morris, Toys R Us, Kentucky Fried Chicken. So, it seems like we live in interesting times that Indian Americans, Native Indians, settle for $500,000, right, for the land that we are occupying, whereas these corporations that actually allow the United States to illegally occupy Iraq and create a vacuum, as Professor Chomsky mentioned last night, to lead to the Middle Eastern mess. I'm a lawyer. I have two specific questions about the California case. I haven't read the decision. I will go and read it today. Number one, you said during the discovery process, the fact that the claimants were Armenian was an argument the German company used to dismiss against your argument. If this is correct, have you reconsidered thinking of a class action lawsuit against this company by using non-Armenians or other ethnic groups from the Ottoman Empire? And it doesn't even have to be this German insurance company. It could be other companies, New York Life, or I don't know, similar category. Number one, have you ever considered non-Armenians as claimants to get a precedent issue then Armenians could follow if you could get a decision? And number two, have you done forum shopping, not necessarily just Germany, France, Turkey, but forum shopping in the United States, aside from California federal courts?
Okay. Maybe I wasn't too clear. It was the law that they were interpreting, not the discovery, not an argument made by either side. In other words, the law, if you read it, because the law is before the court, right?
The law was struck down.
The law, which is in California state statute, is in question. What they're saying is this statute is unconstitutional. It's against the federal constitution. Because California, has a right to regulate insurance, but that's for normal insurance as a state. But when it, in this case, it says step into foreign policy, that's a federal matter, it entered the field that it doesn't belong in, like immigration or bankruptcy, right? Which is written. This is not written. So the statute says victims of Armenian genocide from 1915 to 1923 are allowed another 10 years, their heirs, to file a claim. So that's what it was. But, so they had their head on that. They said, look, this is about something that happened in a foreign country, and here's a state, one of 50, daring to interfere to upset our ally by passing laws that make him look bad. Right? But that wasn't the case, because in the definition section of the same statute that they're striking down, it defines an Armenian genocide victim as what you said. Not only Armenians, non-Armenians, who died natural deaths or were the victims.
Sorry to cut you
But
off.
it's
Just
not what
to
you said,
clarify,
you
now I
misunderstood.
understand and I agree with it, but it seems like the problem was, and will continue to be, for the judges to ask that question, are you asking us to recognize the genocide? And they will shy away from this. So my question would be, is it possible to keep it contract, not going back to the California statute? Is it possible to keep it a contract law issue, or going back to Turkey as a
You
property?
need a new law.
Property.
You need a new law to give the time limit. The time's expired, remember? So this law that extended the time, think of like a basketball game. They got extra 10 minutes. Now that's gone. So, the game is still over. We need
You're
an
trying to
extension.
get over statute of
I hate to-
limitations.
I hate to cut you off.
I get it.
I'm sorry.
We need laws.
We're, at the end, we have one more question that we have time for, and I'm probably going to be in big trouble, but please.
Yeah, I wanted to ask Tom, you mentioned that the United States and other major parties sort of keep the Armenian question on life support as a way of disciplining Turkey in certain instances. Do you have examples of that being done?
I think it happens every day in Washington. It's the usual move, and it's what certainly certain Turkish nationalist groups have actually said, that they're tired of having the United States clobbered, beat them over the head with the Armenian genocide. So it's being used. Okay? I'm not privy to what goes on in the corridors of Foggy Bottom, but I guarantee you that they're saying that every day.
It's not an issue like dissolving the Cyprus occupation or not allowing American access to Iraq and Turkish territory.
No,
It's at a lower level.
It's lower level than that.
Okay.
I'd like to thank our panelists.